Welcome to another episode of Mini Talks. I want to remind you guys that I don't really advertise just a whole lot for the podcast, but I rely more on organic reach. And that means you guys telling other people about the podcast, sharing between yourselves, sharing the episodes that you like across Facebook, Twitter, Instagram, and all those outlets. But remember to subscribe, and if you're on iTunes, leave a review. Review it, help out the podcast a whole lot. And I know there's over 70 podcasts that I have uploaded, and the mini talks I do every Monday. And sometimes I release these early on Sunday nights. Sometimes they're right at midnight. So if you subscribe, they're going to be uploaded as soon as I upload them into the server. So keep it locked here for good entertainment and mind-provoking materials. But this week I'm going to talk a little bit about the justice system, specifically about prosecutors. Now, the justice system is kind of three levels of the justice system. You have the police. Of course, your police are your first contact. You know, they come in contact with the public when anything's reported to them. Maybe it's self-initiated, whether that be incident reports, traffic stops, speaking to victims from follow-up calls, investigations, a lot of different things in that. And police include probation and parole officers, just as well as they do other extensive law enforcement, whether it be local, state, or federal. And so that's that's how people are entered into the system, the criminal systems. Second level, you have courts. And this is where we have, after the initial contact with police, people are put through the courts, whether it's a citation. Sometimes they just wrote a traffic ticket. Sometimes they have, they'll show up to court and do a plea and they'll have a trial. Some are on arrest, whether they plead guilty, not guilty. Some are, more serious lines along felonies. They have arraignments, pleas, sentencing. Sometimes they review evidence before trials. There's sentencing for those that are found guilty. Some are kicked out when acquitted, so they're out of the system. And the last level is correctional systems. And, that's a big system where people are incarcerated. Some go to prison, some spend time in jail. A lot of people do not go to either. And that's one of the things they're talking about with the prosecutors. There's this one thing about, prosecutors is they have a lot of discretion. They have a lot of liberties that they can do. They have also rights they have to look out for from victims and defendants. And the Eighth Amendment comes in as, one of those rights for defendants, that protects them from excessive bail. It protects them from excessive fines once they're found guilty. Also, an extension of that is they're protected from cruel and unusual punishments, which is a whole story within itself. And there's been debate in the past is when does the punishment start? Does the punishment start before the trial, with a bond, with being held in jail before you're guilty? Or does this punishment actually start after you're found guilty and you're sentenced? So there's, some people are, the jury's still out on that one, and no pun intended. Or maybe I did intend that to be a pun. But we have people that go up to the pre-trial and, they put in their plea. Now, one thing I talk about the prosecutors having discretion on is, people that are going to trial, sometimes the prosecutor, or most of the times the prosecutor gives them an opportunity to do a plea bargain, especially when there's multiple charges. And they do this at their liberty. There's a few reasons for that, but I won't go into those reasons. But prosecutors have that discretion, and sometimes they have the discretion whether to prosecute the crimes or not. And the prosecutors also hold the police accountable in certain ways and certain things that they require, and certain elements of the crime that they're directed to find and to put forth, and sometimes it's the reverse. Sometimes it's a prosecutor telling them they don't have enough evidence and they're not going to prosecute, or maybe it's in the prosecutor's interest where they don't want to prosecute because they don't feel like the activity of the defendant is worthy of a crime, is worthy of going to court or being seeking punishment for that person. Sometimes it has to do with whether there's an actual victim or if the state's a victim. You know, state's victims, sometimes they won't prosecute those cases. If there's actual victims, a lot of times they will prosecute, but there's other times that they won't, depending on the circumstance. And when I say they have discretion and liberties, it's something that in the past we have prosecutors that's violated the rights of individuals, and those individuals have served prison time. Some have served over a quarter of a century in prison, and are on appeals, and some of those people have had their rights violated in the court system. The juries were stacked against them. Some of them didn't have the proper evidence. We see some of that today. People claiming, there's not enough evidence to substantiate a conviction, but yet they were convicted. And there's some that say they'd had an unfair jury, and it was proved in Supreme Courts that they had an unfair jury in several of their trials, still been found guilty. And those prosecutors that are violating these defendants' rights aren't being held responsible for that. There's no sanction against a prosecutor for violating someone's rights. Can they be taken off the cases? Yes, they can be taken off the cases. Sometimes it does really, take an act of Congress to get a prosecutor off the case. And sometimes they recuse themselves before it comes to that. I don't have any statistics on that, but I did study a case last semester that it was involved where the prosecutor violated due process rights, other liberties between the 8th and 12th Amendment, and I think the 14th of an individual, and was still remained as prosecutor on the case even after a Supreme Court ruling. But when you have a system that's put together like that, and you have the prosecution that has these discretions that they act upon, sometimes it puts a weak link into the system. And that weak link makes the whole system weak. Something else that I find interesting is when you're on the outside and you're looking in, and the criminal case doesn't involve you. It's common that I see people, before trial, they want the person to be, put to the chair, they're given the needle, put in prison, not have a trial. But yet those same people will want First Amendment, Second Amendment rights, even Fourth Amendment rights. They're willing to take away somebody's Eighth Amendment right. For example, somebody gets picked up on maybe a domestic battery call, and they get the opportunity to bond. That victim may not want that person to bond. Their families may not want them to bond. They would even claim no bond. Even if it was a felony domestic abuse, they would want no bond. Now, we already know the Eighth Amendment protects against excessive bail and excessive fines. Some would claim a high bond would be a fine rather than just a bail, because that's just to keep them in the system to ensure that they get back to court. And there's other ways of having somebody out on bond. That bond is can have different types of things. It can have protection orders. It can have you can be actually assigned an officer to you that kind of like a probation officer, where they make sure you stay away from the victim or within a certain amount of feet, and also make sure you stay off alcohol, stay off drugs. You can even take a drug test. There can be many stipulations of a bond, and if they don't follow, they can revoke that bond and then hold you into a court. So there's a lot of different things that can be done there. And that's what I talk about probation and parole officers. Parole is mainly after incarceration. Probation can be actually before the trial, in some senses. People are put into the system and they're already on probation. They haven't been found guilty of a trial, but it's a type of probation or release on bond, with those certain stipulations. So be reminded that, the Eighth Amendment protects the defendants against certain things, and it's just not once somebody is arrested is an automatic guilt. Just the same way as the prosecutor, acts upon his discretions, and you don't quite think it's fair. It can be unfair one way and unfair the next, But I look at a lot of different types of systems. Now, systems are, they call systems because they're systematic is the way they work. And when you look at a system, that system should operate and be self-contained and should work flawlessly. Some have their loopholes, but primarily the loopholes come with the people that are running inside the systems. You can compare the criminal justice system to even other branches of government or religious systems, or just like a church system. Now, those systems are they're down pat, but it's the people inside the systems that begin to deviate from those systems and weaken those things. And we have to realize that a lot of systems, there's nothing technically wrong with them until you add the flaws of people and I guess you could say, lack of better terms, dishonesty from people that don't adhere to the way the system's supposed to be ran. And they kind of, they're the rebel in the system. They step outside and they do things that aren't quite normal or not normal or on the right on the edge of being illegal. And you have to really take a look at that, because when you have an accumulation of that in any one of our systems, you would think the system is flawed when it's actually the individual that has the flaw. So keep that in mind when you're kind of taking a look from the outside at some of these situations and things that are going on. It's not always just the system. And, when there is that weakness in the system, that discretion, and it disappoints victims and victims' families, usually the police gets the blame for that, because the police are out there on the front lines, and that's what they see visually of the system. We have court TVs, but it's not, you just don't see the court while you're sitting in your house. You actually have to go or keep up with that or read the court dockets to see the outcomes of cases. Police, you can see their activities, video cameras, and they're always in the public view. Correctional systems are a little bit more hidden, but they're similar to the police, of being able to take a look inside much easier than the courts. Some of that is changing, but when you're thinking about the justice systems, thinking about how much discretion that prosecutor has, think about how much discretion even a public defender or a defense attorney has, even a judge. All those people need to be held just as accountable, and a lot of those people are in places that you would consider untouchable. So when you think about improvements of the justice system, start at the prosecution level, start at the level of the judges in the courts, and take a strong look at them, because they influence the rest of the justice system and how we move forward into the future. So I hope this gives you a little bit of information and something to think about. And I'll catch you on the next episode of the Mega Talks podcast.